link. One of our associates should be joining as well for that purpose.
Again, as we indicated, you needed a participant link, which my judicial assistant asked yesterday. So can someone give me what you want to look at?
Yes, it's very short, Judge, but the problem is it's electronic. And so if there is someplace I can email it very quickly, you can have it in 2 seconds.
Well, the problem again is my assistant is doing other things right this second.
I can read it into the record.
Your Honor.
Well, let's do with something else while my assistant is doing other things.
Your own outline suggested maybe the motion in limine I presented about the 2015 issue and Chapter 39, and the instruction he has, although it says it's false imprisonment, is really relates to the 39 matter. I suspect that those two things might. The first one probably doesn't take much time, but we could do those two, and then there's about 4 things in the jury instructions that if we know are disputed, and if we can resolve those, I suspect that Mr. Elliott and I can make a lot more progress on.
Well, then let's do DIN 3411, docket identification number 3411, defendant J. Hatch's motion in limine to prevent evidence and argument concerning a claim for failure to diagnose and treat CRPS in 2015. Mr. Altenburn, your motion.
On that particular claim, the all of a sudden I dropped that file, but we have moved in limine because of the opening argument. The opening argument begins and talks a great deal about medical treatment between 2015 and October 2016. I don't have any problem or concern with that. The situation was an evolving situation that clearly comes in, and conceivably what is in Johns Hopkins All Children's Hospital's medical records on October of 2016 would inform some of the decisions they would make in that time period. But in the opening, it began to feel like he was saying that we should have diagnosed CRPS earlier than we did in that time period, that there was an opportunity to do that we missed, which has never been alleged. And then towards the end of his opening, there was discussion that because there is a theory that CRPS can be cured if it's treated early on, that we could be responsible, that Johns Hopkins could be responsible for all of the damages here, because anything that the other 2 doctors did after that point in time would be after the fact of this defendant's negligence as medical professionals. And that's never been alleged, as I've laid out in the motion, not from the first complaint till now. B, they alleged in the last complaint, and maybe the one before that CRPS is a permanent reoccurring disease, not that it's something that could have been cured at some earlier point in time. And finally, had they raised claims about errors in medical standards for 2015 in their original complaint in 2018, the first thing they would have gotten would have been a motion either to dismiss or motion for summary judgment on statute of limitations, because they knew from their own doctors that they had gone to that they believed that ketamine was the solution to this problem. It was the miracle, and they knew that well before 2 years from not only the filing of the complaint, but from when they made their first notice letter. So I'm not asking that evidence not come in. I'm asking that there not be a jury instruction on a standard of care or a theory about a medical negligence claim prior to entry into the hospital as explained in the complaint in October of 2016, and the arguments that we should be responsible for all the damages because our negligence occurred before their doctors ever saw that the patient also should be excluded.
Is it Mr. Elliott or Mr. Anderson who's going to make this argument?
Yeah, I think this one's mine, isn't it? Your Honor, Tom Elliott again for the reporter. We filed a response, which is DIN 3423, I believe. And this is the plaintiffs are not making a claim for medical malpractice based on 2015. This is, as we say in the response, this is background information. Both sides referred to it. We cite a number of places where the defense referred to what happened before that. So I don't think that we're not going to ask for a line item verdict on 2015. I mean, this is not the instructions in front of you now, but they're in the med mal instruction. If the defense is still planning to blame the earlier doctors, we're going to have a discussion about the level of proof for that. I think it's not clear to us at this point if they're still planning to do that.
Well,
but that would also, of course.
Let me ask you this. What am I supposed to do with Mr. Anderson's comments in opening statement that Johns Hopkins All Children's Hospital missed 7 prior opportunities to diagnose CRPS?
Your Honor, I think that's relevant to how they handled it when she got there. Having missed it, the jury would be entitled to wonder, to infer from that, well, maybe that's why they wanted to say it wasn't.
Where is that covered in the pleadings? Where is that in the 8th amended complaint? Can you point to me any paragraph in the 8th amended complaint?
It's a long complaint. I'd have to dig in, Your Honor, but I think, in the medical malpractice claim, let's look at that.
Beginning, if I may, Your Honor, paragraph 19 under background, which is realleged and reaffirmed of the 8th amended complaint, and follows through with the treatment regimens.
And then 127.
27 as well.
I mean, it is, as I think Mr. Oldenburg said, part of the story. That doesn't mean it's the plaintiffs are seeking monetary relief for that, but it may explain, in their view, something the jury can consider what happened, or some of the reasons for things happening later.
Hold on a second. 127 isn't backwards looking. It talks about terminating Maya's CRPS treatments the October 7th. And then, was it 17 you said?
And
19, Your Honor.
19.
Which is going to be incorporated, right, that's incorporated into the medical malpractice count.
Right, but nothing about 19 suggests any sort of culpability on the hospital's part concerning events occurring in 2015. The point is that, and as I'm sitting here, I thought Mr. Anderson was trying to allege that we're trying some issue involving 2015 when clearly we're not.
Judge, my point of view, from our point of view, and the reason we put that in is the jury had to know the number of opportunities that they had to develop the information such that in 2016, she was again seen on multiple occasions, and we allege, and so if they knew back then and put it into the records, when she came back in, we're not alleging that they should have identified it immediately. Nobody did.
I think you said they missed the opportunity to diagnose CRPS 7 times.
Well, that's true, and most of those fall in 2016. Now, we're not alleging that in 2015 that they malpracticed by coming in, but I don't think an instruction or any type of motion in limine is warranted for background information. I don't really understand what their motion is. If it shouldn't be, based on the court's prior comments, it shouldn't be to exclude the entire lead up to what happened in 2016.
I think that's what Mr. Altenburn is saying. It's your pointed comments gave the impression to this jury that we're trying something that's not contained in the pleadings. And he doesn't want that to happen. I don't want that to happen.
So if the ruling is I am not to address, and my experts are not addressing, so the court knows, my experts are not addressing any culpability for 2015. We're not. And I do not intend to raise any further, other than to point out they received information and symptoms throughout 2015, such that by the time they were approaching the October date, they had every bit of information they needed to come in, including diagnoses of CRPS, which I think is part of one of their claims is that, yeah, we did spot it. It was just one of our many that we thought. So having the statement that they missed these opportunities does not mean at the time. It means that they had the information all along. Now, if the court wants an assurance from me that in closing or in with my experts that I'm not arguing malpractice in 2015, you have that. What I am arguing is that when she started to have a relapse, when she began coming back in 2016, they were armed with every bit of evidence necessary so that none of this should have ever happened. And that is clearly alleged in the complaint. And that has clearly been testified to over and over again by Dr. Newberger, among others, including Dr. Kirkpatrick and Dr. Chopra. So I'm not sure what the defense wants. Motions in limine are not to be used as summary judgments, and they're not to be, usually you don't hear about them in the middle of trial. I do not want and I pray the court that we don't have any instruction that might diminish my standing with the jury on that point. If there needs to be an order that says the plaintiffs are not going further to make any allegations or statements from which the jury may infer prior misconduct in 2015, not misconduct, but medical negligence in 2015, then I'm not opposed to that, because that's not a big part of my case. But I just simply want to make sure that I can reference the history of treatment, because that is absolutely pertinent to the decisions they made in October of 2016.
Mr. Altenberg.
Yes, Your Honor. And it seems like we're not very far apart on this at this point in time. So, you know, if he's giving us his assurance, he's not really going to try that. I as an officer of the court, I will trust that. But I do think, as you point out, that I was left with the impression, it seems like you were, I'm afraid the jury was, that we were trying a case beginning in 2015, and a curative instruction that doesn't need to be a long instruction that simply explains to the jury that the medical malpractice claim is a claim for decisions or treatment made in October and thereafter, informed by what John Hopkins knew from their own records in the past as well. I don't have, we can work on the language of that, but I don't have problems with that, because I agree, whatever was not in the universe, but was in the John Hopkins records on October 7th, 8th, and 9th is material that they probably had access to and could look at. And he can argue that part.
Well, if I may, Your Honor, we believe that this is something that can be handled through the instructions at the end to make very clear. We have no doubt in the ability of the defense to use that instruction to make clear to the jury that this case is about what happened in 2016, not about what happened in 2015. Hopefully the instruction would say, you may consider the information carried forward, or words to that effect, but that's something to be decided down the road. Right now, we object to any order in limine or instruction to the court. I understand and have put on the record that neither me nor my experts are going to raise or testify to medical malpractice, that is a breach of the duty of reasonable care, a deviation from the accepted standard of care during 2015. However, they are going to testify, as they must to lay the appropriate predicate, about the course of dealings and the course of treatment from the first that they got with Maya. They were treating her, in fact, before she ever came down with CRPS, or however you phrase it. They treated her in June of 2015. So that's all background. But we're not going to bring in an expert that says they began malpracticing this case in July, what was the first treatment? 7th of 2015.
Well,
October.
No.
well, because Mr. Anderson has made clear he is not trying that case, meaning a medical malpractice case from 2015. We'll go ahead and take Mr. Anderson at his word for that. Certainly, I don't think Mr. Altenburn was seeking to preclude information about what happened in the lead up. I think that certainly is fair game and relevant to where where these pleadings are. But I do not want there to be claims argued that are outside the pleadings. We've spent a lot of time trying to identify what is and is not being tried. As far as any type of curative, at this time, I'm not sure, Mr. Altenburn, I need to do anything. I'll think about it, but I tend to think that when I am instructing the jury as to the specific claims, if necessary, we can put time frames in there. I think that if we need to do anything, we can probably handle it that way.
And for the record, I'm going to leave that to your discretion. I'm not going to object if that's the way you do it.
I think that's probably where I'm going with it right now, so we'll leave it. So what's next?
Well, I think counsel wants to talk about the jury instructions. What we have next is, and it's or a tennis, and I can submit in writing, but we needed a clarification on the testimony of Dr. Kirkpatrick and Dr. Richards based on the court's order of, now where's the back page of the order? Order in limine, I believe.
Did you tell the defense that you were going to be doing this?
I have not filed anything in writing.
I don't even know what he's talking about, to be honest.
I'll file something in writing.
Well, the issue is I don't know if this is a Mr. Hunter or Miss Crowells or Mr. Shapiro. I mean, you have Mr. Hughes here and you have Mr. Altenburn, but if it's dealing with something that one of the other lawyers is dealing with, then unless you've told them that you're going to do it, then I'm not sure we should be hearing it right now.
Yes, sir. And for the record, this is the court's, we'll be moving for rehearing on the court's September 22, 2023. And it's really, it'll be rehearing or more appropriately for clarification. I want to establish the bounds within which Dr. Richards can testify concerning causation, and also Dr. Brewerton's ability to testify concerning the standard of care for the psychologists and psychiatrists at Johns Hopkins that were involved.
Okay, well, you first started talking about Kirkpatrick, then you changed
I'm
to
sorry, it's not
Richardson's.
Kirkpatrick. No, that's my mistake. There's too many doctors in this, Judge. Brewerton and Richards.
So that's DIN 3410. I'll follow your motion. And when do you anticipate those doctors testifying?
Not until later on next week, maybe midweek.
So let's get your motion filed and we'll carve out time to address it.
Very good. I just wanted to avoid bringing somebody in or asking the wrong question.
What's next?
I would suggest we try to resolve it, whether to give something on Chapter 39 as soon as tomorrow morning.
Okay. Is there language and I think you gave me something
I have
Friday, and
I gave you something Friday, and there's actually a paragraph from what I did earlier that might also be an alternative. I'm happy to kind of read them aloud to you as well if you want me to.
Because it's sitting in my office at home on that particular piece of paper.
Is this 3420? docket index number 3420.
It probably is, Your Honor. I don't know that I've got that piece of paper right in front of me at the moment.
Looks like it was filed 9/25.
This looks like a 2-paragraph, but what you gave me the other day was a 3-paragraph.
Initially, I gave you one in writing, Your Honor, and I realized I wanted it in the record. So Mr. Ellicott's correct. I went ahead and filed it, and when I did that, I just did it, the 2-paragraph version of that
Well,
is what I did.
this is referenced to DIN 3420 for the clerk. And what's written in 3420, Mr. Altenberg, looks like your first 2 paragraphs and not the 3rd paragraph.
They're very, very close, maybe a word or two off, but basically it says, during opening instructions, I told you that Johns Hopkins All Children's Hospital reported suspected abuse to the Department of Children and Families in good faith, and that the hospital cannot be found liable in this case for having made that report. After that report was made, the Department of Children and Families filed an action against Beata Kowalski. In that action, the department obtained a court order on October 13 at 2:30 a.m., allowing the department to take custody of Maya Kowalski, subject to the court's jurisdiction. Johns Hopkins All Children's Hospital did not take Maya Kowalski away from her parents. It is not liable for the court's decision to enter this order. And if you wanted to, it could go on, enter this order allowing DCF to take custody of Maya Kowalski. Now, I would point out, by the way, in the one I argued earlier, I'd asked for the sentence, Johns Hopkins All Children's Hospital cannot be found legally liable for making the abuse report for the department's investigation of that report, the filing of the department's lawsuit, or the entry of the shelter order on October 14th. The claims in this case do not include claims for those matters. And I had taken that original language essentially out of the partial summary judgment order that you had granted in part concerning the parent agency of Sally Smith. So that language might still be preferable to me because we've already gotten in, well, for example, yesterday, Dr. Duncan talked about getting a big disk of medical records from DCF. Well, she got part of their investigation. The fact that these things are is beginning to come to this jury. I feel like the jury is probably a little bit lost and confused yet about what the story, how to put the pieces of this puzzle together. And so in some ways, I would prefer to have all 3 of those taken care of now. But if the court only wants to go as far as the taking away issue, the one that I presented in the filing a couple days ago.
Why don't we do this? Why don't you put your language on here? It's not going to help Mr. Elliott, but it's going to at least be able to help Mr. Anderson and me. If you just go up to the document projection, see if I can figure out how to do that.
I do have 3420, Your Honor, so I have the first 2 paragraphs here.
You want me to come up here, Your Honor?
Yeah, I'm just trying to figure out how to turn that on from here. I think there's a button you have to push.
My expertise with this is limited, so.
Let me.
The power is on, and power's on. Well, now it's on. Now it's on. Okay.
Your Honor, when you're ready, I do have some comments on this.
Yeah, I'm just trying to get the document camera going. Mr. Hughes, is there a power button?
Yeah, we pressed it, it was red, and then we pressed it, it went blue.
And there's a
Mine's on.
there's a blue showing this device being on.
Mike, can you help us get this Elmo? I've got it on
got it.
lectern right.
It's up on ours. You need to turn it the other way, though. It's sideways on us. That's better.
Tell me where. Okay.
And you can focus it on the top there by twisting it. I have a lot of Elmo experience. There's a knob.
I
underneath there.
continue to have
Underneath
trouble
it's
getting the
knob.
gallery in.
You can make it there, other way.
Well, the gallery screen, so I usually have to turn it off and then turn it back on.
Yeah, I think we can work with that.
We'll just do this.
Oh, and it just went off.
Well, I did that on purpose because I'm trying to get the gallery ones open. Turned on. There we go. I don't know why it does that. Okay, thank you. Okay. And so, Mr. Elegant, we have the original version, what Mr. Altenburn put on, I guess, gave on Friday. So do you have that sheet of paper?
I think I do somewhere, but what I've been working from, I assumed that this 3420 was revised, and that was what we were going to be talking about. So I'm trying to find the other one, but
I mean, what's on the screen may possibly be a couple words off what I filed, but I'm not positive.
They're pretty close, but what we'll do is we'll tell you what the difference is. But just as an overview, Mr. Elliott, what is your view of at least those first two paragraphs?
Well, Your Honor, we filed a response to the earlier version, and it is DIN 3424. And I mean, the first thing is we don't see why this is necessary to interject this as the plaintiff's case. I mean, simply saying somebody got records, for example, from DCF hasn't told the jury. I mean, you already told them. You already told the jury in the opening that John Hopkins is not responsible or is immune for the report. The jury, I'm sure, will hear over time that the report led to a custody order. But the problem with this instruction, I mean, paragraph 1 just repeats what you already said in somewhat different wording, the immunity. Paragraph 2 is, in our view, way too slanted toward the story that the hospital wants to tell. It leaves out your admonition in the opening instructions that the DCF proceedings do have nothing to do with the plaintiff's claims. In other words, the plaintiff has a claim for false imprisonment. Looking at this, I mean, it talks about, in that department obtained a court order allowing the department to take custody of Maya Kowalski subject to the court's jurisdiction. I mean, are we going to put in there they didn't have permission to do it between October 7th and October 13th? I mean, we have the instruction that the alternative or the addition that Mr. Anderson referred to earlier, it's very short. I could probably figure out how to share the screen here. I'm not sure if that would help for the people who are live, though.
Your Honor, can you inquire of the clerk whether she was able to make any copies, receive it? So it went into your JA. Okay.
The only thing my JA brought in a moment ago was plaintiff's proposed interim instruction on false imprisonment. That's
it.
2 sentences long.
Yeah, that is it, Your Honor. It's labeled false imprisonment, but it really goes to, because it needs to be, the jury, you've already told them this, but if we're going to start reiterating things, they need to be told, if they're being told again, basically that the hospital has immunity for DCF, they need to be told, and that immunity and the DCF has nothing to do with the plaintiff's claims. So that's what this was an attempt to do, to say, you're going to hear some facts, that's facts and circumstances, that some that are and some that aren't relevant in making your decisions. And talking about the shelter order, which is in paragraph 2, has no effect on the plaintiff's claims I instructed you at the beginning of the trial, and that I will instruct you at the end of the trial, including the claim for false imprisonment. And we could go on and say, in the videotaping and the pictures and so forth, but if they're being told, the jury's being told, well, they were allowed to do this at certain points of time, they need to understand that the order did not immunize them from the plaintiff's claim that they were not allowed to do it at other times.
I mean, from a conceptual standpoint, what's the harm in telling the jury the specific date and time that the court entered the shelter order?
I can speak to that, Tom, if I may. That is that it misleads the jury into believing that that one order somehow precludes a number of the, well, already testimony that has been made in court and will be made through the experts and through the additional witnesses and through Ms. Kowalski. And I'm concerned that there are 5 orders that we're talking about here. We've got orders from October 14th, the original shelter. We've got November 11th, November 12th, January 3rd, January 14th, April 20th, that all change the scope of the custody. Now, they don't release from custody until the 13th, actually, of January. But the concern is, if we start down this road about the effect of orders and only focus on one aspect of it, it will affect all of our causes of action, and especially our medical malpractice cause of action, because the jury and the intentional infliction of emotional distress and negligent infliction of emotional distress, because the jury will be left throughout the remainder of the testimony, and they'll just, being jurors, they'll just turn off to a lot of the testimony, believing the impact of that order on the causes of action is much, much greater than it actually is. The court's already been down this road and has done a yeoman's job of going through all of this to find those parts that are not subject to immunity. To come back in and raise an oblique reference to an order is going to completely, well, it'll affect every aspect of our case. And so we submitted a very basic one if the court determines it's absolutely necessary for some reason. But all of these issues, first, the court made, we all came up with, and the court read an instruction at the start that was directed towards the first 2 calls being immune. We all understood that. I acknowledged that in my opening. And then I relied on the court's statements in coming up with these and the court's instruction in the manner in which I delivered my opening about what the story was and what they can consider and not consider. And so if we go in at this point, and I beg the court not to submit anything to the jury right now until you've heard more of our case, because there is a strong argument to be made here, Judge, if you'll just listen to some of our witnesses that are coming in. There's a strong argument to be made that none of this should have ever happened had Johns Hopkins diagnosed when they should have diagnosed and not diagnosed when they misdiagnosed. And so I beg the court's indulgence that if you do come up with something here, which we do not believe is appropriate, we think all of this can be taken care of at the end of the case, but if you are going to, please let us get through another week of testimony. I need to say at this point that Dr. Kirkpatrick called us late last night and he's ill. So he's not going to be able to testify tomorrow afternoon. So we are strongly considering putting Maya Kowalski on if the court and counsel will again indulge us. She has some testimony. It is very difficult to get out of her. I know I'm off track here, but the point is I really, really need the court to hear more of this case before we consider focusing the jury on a particular point. From their point of view, the way I was thinking of it, reading this, is they're going to go, what's all this testimony about her not seeing her mom and dad and anything? So, the judge just told us that's all out. That was the impression I got, and I think that this will have an impact on the jury far, far more than what any of us in this room are contemplating, and I'm very worried about it.
Well, let me go back to your first statement.
Yes, sir.
Of your speech there. How is it misleading to the jury to tell the jury the specific date and time of the shelter order? That I don't understand. How could that be misleading? I mean, I was somewhat perplexed when no one said it in opening talking about the specific date and time. Now, perhaps that's because now you kind of changed how you're approaching this case and not talking about DCF. That's fine. But no one said it to the jury. And so what is wrong with telling the jury the specific date and time that the court took jurisdiction over Maya?
Because the term jurisdiction and the impact of a court order to your average citizen is overwhelming. And because the jury will then conclude that anything that happened after that date is really kind of irrelevant to everything. Because if the court ordered this, why are we listening to any of this stuff? And it will diminish the impact.
The court did order it.
The court,
and so we're not to talk about it now?
We're not to talk about it until we have a chance to put on our rebuttal, and so that this court and the jury can hear exactly what went on with the entry of those orders, and also so the jury can hear the testimony of my experts about how, and they won't, I don't know if they're going to mention the order specifically, but about the timing and the causation and the other theories of the case. That's all going to be, I am willing to wager you're going to get a lot of closed body language and looking up in the air and just kind of not taking notes and looking around as to any of the testimony that goes after that date. It presents to the jury a cutoff date where for the average person's mind, after that, well, the judge has got control. Who cares what happens?
But there are cutoff dates in the pleadings because of how you pled the case and how I've had to rule on the good faith reporting. So there are specific dates and times. And what you're suggesting is we disregard those dates and times, muddle everything together, and then not tell the jury what those dates and times are. I think that's very misleading to the jury.
All right.
So, like I said the other day, we're going to do this. We're going to make a statement, and it's going to include dates and times.
Now,
so
with that,
that's why the other day I said, we're going to do this, come up with something, and your side ignored that. So that's fine. But understand that I said that, we're going to do it, and then you didn't do it.
we did submit something this morning, and let me explain also that.
I don't see any date and times on this.
No, it needs dates and times. From our position, it didn't need to have dates and times. It simply had to make the point that at some point the court entered an order. But if I may, Your Honor, if it's the court's position that the jury should be informed of the date shelter order, then it should address solely the fact of the false imprisonment, and it should only address, and it should also mention, I will instruct you at the end, the portions of time you may consider for false imprisonment. That is the truth of the matter, is that this really only applies, this order that we're all contemplating here, which is the shelter order. Am I correct in this? And so if the court is of the opinion, and I understand where you're coming from, Judge. We don't want to mislead the jury in any way. That's not the plaintiff's point of view. But it has to be limited enough so the plaintiff has the opportunity to present their case without the jury concluding that, big deal. And so, and there are multiple orders. And so if the thing gets broader than that, then we have to get into all of the timing, because every one of these orders change the different obligations and times and who could visit and not could visit and all of that, which I don't think is the court's purpose here. The court's purpose here is to let the jury know that a shelter order was entered at this time. I understand. But it should be limited to false imprisonment, and it should have something to say, I will at the end instruct you of those periods of time. Or tell them, Judge, these periods of time, there was no authority under the court's order. And that way, you can inform them and the plaintiffs won't be jeopardized.
I feel that we need to tell the jury the times to which the false imprisonment is allowable and false imprisonment is not allowable.
Thank you, Judge.
I think that is fair to the jury. I think it has fidelity to your pleadings and has what we've been talking about for the last 2 years. So
yes, sir.
I would like an instruction that has the dates and times specifically. Now, I get, and I've indicated this in prior orders, that there are times that Johns Hopkins All Children's Hospital is potentially liable for false imprisonment. I agree that there are those time periods. Let's just tell the jury what they are. I don't think we can need to hide that.
Reserving on our position on whether one should be given at all, but the plaintiffs find that acceptable and would agree with the court in that type of wording.
Mr. Alden.
For the record, first of all, the reason I'm asking for the specific issues about taking away is that we've now had 3 lay witnesses who understandably don't understand the details of the law tell the jury that they or Johns Hopkins took Maya Kowalski away from the family. Linda Brown did that as the 3rd one yesterday afternoon. So the jury are adult learners, and you're correct, they need to get this in segments, and that's the segment right now they need to understand, is that we didn't take the child away. The court did that, and we're not liable for that. That said, while she was in the custody of DCF and under the jurisdiction of the court, she was in our hospital. So even though she was in our hospital, that didn't give us immunity if we locked her in a closet for 2 days. And what the 3 things they are alleging is that while she was in the custody of DCF, we didn't release her for a couple days in October. We put her in an EEG room for 44 hours sometime later, and that we put her in a room to take photographs of her for a couple hours in January. Those are the 3 events of false imprisonment. They don't have anything to do with the custody issue, and if down the road the jury, again, as adult learners, need another segment to explain that, I am totally fine with that. And as to the visitation issues, as I've watched the last couple of days, I realize it's not something that we can just give them a one sound bite to explain. And he's probably correct. There's 4 or 5 orders that probably the simplest thing is to put them into evidence, either in their entirety or redacted, because there's some judicial comments in them that maybe we don't want the jury to see. But one way or the other, we can deal with that too down the road. But right now, I'm not prepared to tell you what I think should be told to the jury about about visitation at the moment.
Well, I hear what you're saying, which is a little bit different than what Mr. Anderson and I were just talking about on false imprisonment. Conceptually, I understand what you're saying. The concern is because of the dependency court and the different orders, the status did change at different times. And so
Visitation status did
correct.
change. Right. That's correct.
And so that might be another one where we've got to identify a specific date and times.
If you felt it appropriate to give even language tomorrow morning explaining that there are additional orders on visitation and I may discuss those with you further at a later time, I have no objection to that.
I believe that they are trying to put their case in our case through the court. And I further believe that if we simply introduce these orders, we're going to have a jury so confused they're going to be out for 3 weeks. And they're going to have a question a day. You just know it's coming when they try to interpret 4 orders, especially when the end one says, oops, sorry, all this was kind of by mistake. We didn't have enough evidence here. So what I would suggest, Judge, is that we get together, counsel, we do a timeline or figure out how these orders interact so we can come up with an instruction for the jury at the end of the case that says, now, in considering the plaintiff's claims of false imprisonment, here are the dates. In considering the plaintiff's claims of allowing visitors, here's what's allowable, or here's the parts that here's what the order said. I think that putting these in, and I understand the defense might be worried, well, are we waiving anything? And for the record, I'm not, I'm taking the position that they don't need to put these in to get the information in front of the jury, and I don't argue either that it, in any event, putting just the orders in and then having the various witnesses interpret the orders usurps the jurisdiction and the duty of the court. I'm not telling you your duty, but you already know. I didn't mean it that way, Judge, but you know what I mean. It gives the power of interpretation to the witnesses. That's not correct. How these orders interact with the evidence is up to this court. And so I would oppose putting the orders in, and I will stipulate in the record if the defense needs anything to protect them from not putting the orders in. But I think that's the best way to handle it according to the law.
Well, there's a couple of issues that I'm hearing right this second. One issue is Mr. Altenburn's issue that plaintiff's witnesses are coming in and said the hospital took the child, which legally is incorrect. The hospital didn't do that.
Well, they did actually the first 24 hours.
And
Well,
first 7
that's a false imprisonment claim, which is allowed, but the physical sheltering of the child is not something that the hospital did. That's something the dependency judge found there to be probable cause for the sheltering of the child.
I understand, but again, I come back to the fact we're talking about the wording of, I think, 1 or 2 witnesses about taking the child. The simple facts are that before that order was ever entered, they had no basis for keeping that child, and therefore they took the child and kept her away. And this was the start of all of these proceedings. They did not gain jurisdiction by making that phone call. The hospital did not have jurisdiction. They did not have an order. They had no legal cause. They had no reason. Now, they're going to argue, but they had no reason under the law to take Maya away from her parents to start with. If I understand the court's interest in saying a shelter order and parts of this thereafter are actionable and parts are not, I get it. But insofar as that wording is correct. And there's no need, in my view, to correct and take away and diminish from the fact that from the first part here, they didn't have squat for legal authority to take this child. They made that decision up, and if the court will allow, and that's why I'm hesitant to even, I'm begging the court to hear more of our case in this regard. But once the evidence comes in, I believe it's going to be very, very clear the reasons why and what they did to the child had nothing to do with whether they believed she had a victim of Munchausen by proxy or whatever it morphed into lately. And so I really think the court needs to hear more of that case, and if it needs to be set out, the specific dates that are not actionable, fine. I still say that that's something for the end of the case, and I relied on that in my opening. So what I would propose right now is that we be given the opportunity to develop an order. Now we understand the court's position, but that we should not be obligated to backtrack on testimony that was technically true. It was true. They did not. They kept this child because they stated AMA, and we can prove, if I had my enlargement here, I'd prove that they specifically said a patient here can leave at any time. And that was in their rules, which we'll put into evidence, and that was in their protocols that we'll put into evidence. So they violated their very own internal rules by keeping that family their AMA. AMA, against medical advice, has no force of law, none. So they took Maya and took her away. What's wrong with the witnesses saying they took her? I don't think that's necessary, Your Honor.
Well, let me hear from Mr. Altenburn, then I'm going to tell you where my thoughts are.
As to the period between the 7th of October and the entry of this order, I think there's going to be disputed facts about time periods and whether she could or couldn't leave the hospital. And so we do probably need to hear evidence on that. The testimony I've heard, especially like yesterday, was Beata called this woman and said they've taken it away. They're talking about the shelter order, not this earlier point in time. And so as to this earlier period, I'm sure that the evidence will be developed, but it wasn't that we, again, the issue of whether we took her away from the family is not something that is being accurately explained by the questions asked and answered by the witnesses in this court, and we needed an explanation of that. And so I believe that this is an accurate explanation of it.
This is where I think the testimony, I think there's enough testimony in now that it's important that we give the jury some context in how it should be evaluating the testimony that's coming in. Specifically, I do think we need to identify the periods of time associated with the false imprisonment claim. I also agree with Mr. Altenburn that the entry of the shelter order is not the hospital taking the child away. And I think that needs to get made clear to the jury. Because contrary to Mr. Anderson's argument, I don't want to have this perpetual testimony over and over and over again on an issue I know I'm already going to tell the jury that the entry of that shelter order is not taking the child away, is not the hospital taking the child away. I already know that. I know I'm going to say that. So I am fine doing it in one combined instruction if we want to break it out into multiple instructions. I do think, although I don't think we need it tomorrow, I'm not opposed for it tomorrow, but I do think at some point we're going to have to identify for the jury the changing nature of the dependency court's orders, and again, on time frames. Now, one other corollary to that, which was referenced, and I agreed with Mr. Anderson the other day, and I still agree with him, is sometimes the order said X, and then there is either an interpretation by the hospital or a request to, I want to call it HRS,
DCF.
DCF now, to DCF. That isn't part of the court order. So I'm not,
Right.
I don't think that portion should fall in my instruction relative to the nature of the dependency court's order.
And
I agree with Mr. Anderson on that
And
part.
I think I'm not disagreeing to any great extent on that, that the order, shelter orders are a standard order, and the other orders, I know that there's actually evidence that Ms. Beatty called to get explanation because two sentences seem to be inconsistent ones. So to some degree, it's going to depend upon, I'm assuming this is all coming in on intentional infliction of emotional distress, by the way. It's not an affirmative defense that I've got, but it's going to have to come in as, whether we, I don't know whether negligently is the right word, but whether we properly implemented these orders when we received them. And there certainly is going to be some disputed evidence on that issue.
And at the end of the day, I'm going to look to the lawyers if we're going to put the orders in, or it's going to be an instruction, or both. But I do trust the jury, so I am, when in doubt, I'm going to put the order in. If y'all are on a jump ball, and I'm probably going to put them in. Whether I do it with an instruction that kind of explains, I might do that.
And I provided that instruction earlier. They had all of them in it. It's a hard read. I'll put it that way. I don't know that I would want to read that to a jury if I was sitting where you were sitting.
Okay. So, given my statements, Mr. Elegant, hold on a second.
Sure.
Given my statements, do you, and I guess this is a Mr. Altenburn and Mr. Elegant question, take my statements and try to fashion something, or are we sitting here doing it by committee right this second in open court?
You want something like what we have now, but also has some explanation of the false imprisonment periods in it? Is that what you want?
I want to identify dates and times. I do not want to give an impression that the entry of the shelter order immunizes the hospital from conduct, because clearly that's not what is the court's intent.
Okay.
So, and I think that was where Mr. Anderson was going. He didn't want the instruction to have a judicial gloss that the jury would then disregard evidence.
Rather than trying to do that on the fly, if Mr. Elliott has time, I would think this afternoon he and I can get on Zoom together and probably get very close to what you want.
That works for me.
Okay, thank you. Now, Mr. Elliott, was there something else you wanted to say on this issue?
No, Your Honor, I think you just covered it there because you reiterated that we need something more than these two paragraphs. We need something that says, look, this doesn't affect the other claims. It doesn't affect the claims the court has found are viable to go forward for the jury to consider. So I think we need some, let's see if we can work out some language on that. And I'll talk with Mr. Anderson and Mr. Whitney before that so we're all on the same page.
Okay. Let's change subjects for a second. And, you know, Mr. Hughes, I don't know, I assume it's going to be, well, I don't know who's going to do the cross of Maya Kowalski, but are you telling us, Mr. Anderson, that Kirkpatrick's not happening tomorrow and we're having Maya Kowalski?
Let me tell you exactly what I know, again, as an officer of the court. We received a phone call. Dr. Kirkpatrick is vocal about when and how he wants to testify, but last night we received a phone call which I was able to return this morning, in which he informed me that he has some kind of bug, as he put it. It actually sounded in the background like he did have digestive problems. Anyway, I take him at his word. So I asked him how long. He said he didn't think it would be good for him to come in anytime over the next couple of days. That leaves me with a big hole in my case. Maya Kowalski is a possibility to come in. Her testimony would be limited, and it would be limited to really the period that she was in the hospital and those events. And frankly, the reason, Judge, is that right now the jury has not gotten the big picture at all. They think this case is about a statue and not being able to pray. And so what we wanted to do was to put her in for a given period. The alternative is this. If the court says, no, it needs to all go at once, we'll hold her out and we can play depositions and maybe find one live witness for the afternoon. We have Dr. Chopra. He may take it into the afternoon. So that's all I know.
Well, let me throw this out. And Mr. Hughes, I don't know if your other folks are listening in or if you've got the ability to convey a message to them, but I was going to talk about our schedule for next week. Friday afternoon, which I guess is October 6th, and I think that's one of the days that we previously talked about, which was a maybe. Mm-hmm. The afternoon, we're not going to be able to have court. We can do court in the morning. Because we seated a jury faster than I anticipated, I feel like we're ahead of our schedule right this second.
Right.
So I was going to suggest and get the lawyer's view about, you know, if we take a half day on Friday, do you want to take a half day sometime else during that week? Or do you want to just take all of Friday off? Or do you want to leave at 4 o'clock on Monday through Thursday? Or now, if we've got an issue with Dr. Kirkpatrick, if your other doctor, and I forgot, who do you have else coming in?
Chopra is coming tomorrow from Boston.
In the morning?
Yeah, I hope. He's supposed to fly in this afternoon.
Okay, so assuming that he goes in the morning, do you want to take the afternoon off and then just not take a second half day next week? Or what are your thoughts as far as how to proceed?
Let me be frank, Judge. We have to fly in a lot of people. And because of that, and because schedules constantly change, we could use a day off now and then to prep and to get these people in so that this thing moves through efficiently and without a lot of wasted time with exhibits and so forth. So Taking off at 4 o'clock on the days we're here doesn't help the plaintiff that much in terms of, because frankly, I'm pretty burnt by the end of one of these days. It's hard to stay up late and adequately prepare witnesses. So I could use a day off about every week. I believe that we're way ahead of the schedule, and that's all I'll say.
I'm certain we would rather have all day on Friday than to have bits and pieces as well.
Okay, but if we do all day Friday, then that means effectively we've got Thursday, Friday, Monday, Tuesday, Wednesday, Thursday without a break.
That's right.
We'd prefer a half a day on Friday and a day sometime next week. Actually, when we first started talking about this, before it morphed into 8 weeks, the court was contemplating taking Fridays off. I don't know that we need to do that. I don't know that we're that far ahead of schedule. You're keeping count better than us, Judge. But from the plaintiff's point of view, in our case, this trial is going to go a lot smoother if we have at least a half day and perhaps a day now and then during the week.
Okay, so why don't you get with Mr. Hunter and kind of get an idea as to what you want to do about next week? You know, I feel, and I think this is kind of one of the things I said earlier, is when you have a really long trial, I mean, this is a marathon. It's not a sprint, and I want the lawyers to be able to do what they need to do outside of court, and I recognize that there's a lot of work that has to be done outside of court. So I am fine if we take 2 half days next week if you want to make it a full day on Friday, but it just seems like that's a lot of court days between now and then, when we've got a little bit of time that we could allow for a little bit of flexibility.
To be clear, I think Mr. Anderson was maybe talking about half a day this coming Friday, but that's not what you're talking about.
I was talking about next Friday, October 6th.
Yeah.
We prefer a full day off. That's better for us in terms of getting people in and having the time to coordinate the witnesses with the exhibits and figure out. And remember, we still have a bunch of exhibits we need to work through with the defense and perhaps with the court. So, extra time is always good. We'd prefer to have a half a day this week only for scheduling purposes, to allow us to figure out. I prefer not to put on Maya Kowalski this week. I think it would be better for our case if we did, but I think it's going to be a long process, and it's highly emotional. So I'm at a bit of a
what about this? And Mr. Hughes, I don't know if you've been able to get a hold of them, but what about assuming Dr. Chopra's plane arrives on time, that we do Dr. Chopra tomorrow, and then we can spend the afternoon hashing out whatever Mr. Altenberg and Mr. Elegant resolve tonight on this instruction. And so you would basically have a half day of testimony tomorrow, full day on Friday, and then we'll just...
I only stood, Your Honor, because we also have a physical therapist that has arranged her work schedule to be here first thing in the morning. She won't be a long witness, so that's just a heads up that we prefer her and then Dr. Chopra.
But she won't take long.
That's fine. And if we have to, finish them up an hour after lunch, I mean, the idea is to give you a little bit of time on Thursday. I mean, I'm just thinking that this might, because of the Dr. Kirkpatrick sickness, and I will tell you, and I'll tell us again, I think since there's a lot of people in this courtroom and a lot of people out and about, that if someone's sick and if we can rotate their time to a little bit, I think everyone would prefer a person who's not feeling well not come in.
Yes, Judge, we agree 100%.
The worst thing that's going to happen to us is if you all got sick or the jury got sick, then we're in serious time issues then.
Plaintiffs agree.
So just so I'm clear, because we're going back and forth, the plan for tomorrow is Chopra
And it's Rachel
Rachel DeYoung,
Rachel DeYoung.
the assistant. Okay.